Ghislaine Maxwell has just dropped a bombshell. In a new court filing, she claims that 25 men reached secret deals, secret settlements in the Jeffrey Epstein saga, on top of 4 who were never indicted too. People who were not charged. The government allegedly hid this information from her. Gotta break it down if this is true. What it could mean, who these people are.
Something is building again, and it's not subtle. It's not one of those quiet stories that flickers for a moment and disappears. This is loud, persistent, and growing in a way that feels impossible.
Sex trafficking minors sentenced to 20 years in prison. She claims that 25 men, maybe friends, associates of the deceased financier, have been protected under secret settlements, secret deals, and that this information was not revealed to her during her trial. This is on top of what she claims are 4 other individuals, alleged co-conspirators, who were never charged. Obviously, I have thoughts. Is she telling the truth, particularly given her past, in light of what she's trying to do now? If this is true, number one, wow. And who are these people? What is a secret settlement? Can we ever find out? Can the public ever find out? So I'm made of questions. I'm bringing on an expert right now to tackle all of this. I'm bringing on right now former federal prosecutor, criminal defense attorney, Gene Rossi. Jeans, thank you so much for taking the time. Really, really appreciate it. Okay. Before I get into any of these alleged people who made secret deals, first, just to provide context, just so our audience understands, this is a part of Ghislaine Maxwell's habeas corpus petition, okay? Now, we know that the Supreme Court previously denied even hearing her appeal of her conviction. So for anybody who doesn't know, just generally speaking, Gene, what is a habeas corpus petition and what can a court do with it?
That's a great question. The most famous habeas corpus petition that was granted is a famous case, I think, from the 1970s, Brewer versus Williams. It was a murder of a 10-year-old girl on Christmas Eve in Des Moines, Iowa. And it was a state case, and the defendant, Mr. Williams, had mental health challenges, was recently released from a mental institution, and he strangled and mutilated and killed a 12-year-old girl on Christmas Eve. And it went up through the state system, exhausted all appeals, and then Mr. Williams filed a petition in federal court called Brewer versus Williams. Who's Brewer? Brewer is the warden where he was being held, but that's a state case. And it went up to the U.S. Supreme Court, and they reversed. There was a violation of the right to counsel, new trial, he was convicted again. That's a state case. This is a federal case, and the same standards apply. Miss Ghislaine Maxwell is filing a civil lawsuit, not a criminal, a civil lawsuit as a petitioner, alleging that constitutional provisions have been violated, and she was convicted, and it was a miscarriage of justice. She raises about 9 points in her pro se petition that she allegedly wrote. She probably had some jailhouse lawyers, but 50 pages, or give or take a few pages. It's a civil lawsuit, and the burden of proof is preponderance that she has to bear to show that a constitutional violation occurred. And what would be the violations in this case?
Right. So just to be clear, in other words, this is somebody saying their detention is unlawful, right? And she's saying there's substantial new evidence that has come out. Throw out her conviction, throw out her sentence, that when you look at lawsuits that were filed, government disclosures, investigative reports, documents, it's very clear, right, that if she had this information, her whole trial would have been different. Her rights were violated. If I'm understanding it right, yeah, there's about 9 points. Just before we get into it, how often are these successful? I mean, how often can this result in a conviction being thrown out or a sentence, her being resentenced?
I can give you 2 good examples. One involves Gene Rossi. I convicted.
Lines are filling up in the way people are suddenly paying attention to details they ignored before, because once again, something tied to a story that never really closed is back in the spotlight. And this time it's carrying a different weight. Not just speculation, not just recycled headlines, but fragments of information that feel sharper, more direct, and harder to brush aside. And that's what's putting everything under pressure. Because when reports start circulating about hidden details buried inside old files, it changes the entire tone of the conversation. It takes something that people thought they had already processed and reopens it in a way that feels unfinished. Like the story was paused, not ended, and now it's picking up right where it left off, but with more intensity. That's why the reaction is so heavy right now. It's not just curiosity driving it. It's something deeper, a sense that there's more here than what was originally.
2006, her name was, I'll call her Barbara, fake name. Barbara Smith, that's a fake name. I convicted her, she got sentenced to 7 years. About a year later, she filed a habeas corpus petition. She had counsel, great counsel, and she argued that the prior attorneys did not give her good, adequate information regarding plea negotiations. Judge T.S. Ellis III, who treated me like a son, and he passed away a few months ago. He was a legend. He had the 2255 habeas hearing. He granted the petition. After he granted the petition, 5 minutes later, she pleaded guilty to time served. So I lost that hearing. Right. So it's possible. Second example is there's a famous case. It's a state case. It's Commonwealth of Virginia versus Justin Wolf. He was sentenced to death for drug trafficking and allegedly hiring somebody to kill a customer. It went up through the system, and the Virginia Court of Appeals and the Supreme Court reversed the conviction. It's now being appealed to the U.S. Supreme Court, habeas petition, and that's all I'm going to say about it. Okay. Because I'm assisting in that case. But it's possible to win both a federal habeas petition and also a state habeas petition. Yes.
Okay. Got it. Okay, so we're going to go through some of her points, right? She says there's juror misconduct. The government misrepresented evidence. She brings up Epstein's non-prosecution agreement, back in the day, the one that he signed to get him away from being charged federally, because she has always argued that she was covered under that she was granted immunity. Maybe we'll get to that. But we got to start with this bombshell, okay? So this is the language directly from the filing. I'm going to read specifically from certain parts about these co-conspirators, these secret agreements, okay? Like this, quote, "The secret settlements with the 25 men were hidden from the petitioner," meaning Ghislaine Maxwell. "That information would have changed the outcome of the trial, and petitioner would have certainly called the men as witnesses. The degree of contamination and collusion between witnesses, combined with withholding of Brady material by the government — Brady material is evidence that helps the defendant, needs to be turned over — quote, "that would call into question the credibility of every complainant that interfaced with plaintiff's lawyers, all of them would have changed the outcome of the trial." And remember, there was always a lot of litigation with respect to Epstein and Maxwell that was in the background of the criminal case. So that argument that information was withheld from her and her team is very significant. And then you have this argument of selective prosecution, right? That she is being singled out, that other people could have been charged, but why is she the only one being charged like this? Is it an unfair prosecution? Quote, "A defendant moving to dismiss for selective prosecution bears the heavy burden of establishing, at least prima facie, that while others similarly situated have not generally been proceeded or prosecuted against because of conduct of the type forming the basis of the charge against him, this person has been singled out for prosecution." That's one thing you have to show. "And that the government has a discriminatory selection of the defendant for prosecution." And so here she says, quote, "None of the 4 named co-conspirators or the 25 men with secret settlements were indicted." And then there's this, how former Attorney General Bill Barr, quote, "admitted that post-Epstein's death, they were looking for someone to indict for trafficking."
Presented that the version people accepted might not have been the full version. And once that idea takes hold, it spreads fast because nobody likes feeling like they were only given part of the truth. So people start digging. They go back through old material, old reports, old statements. Things that didn't stand out before suddenly feel important. Words that were overlooked now seem loaded. Moments that passed without much attention now raise questions. That's how everything starts to shift. Because when the same story is viewed through a new lens, it doesn't look the same anymore. It looks incomplete. It looks like pieces are missing. And when people realize that they don't just accept it, they react. That reaction is what's driving everything right now. You can feel it in the tone. It's not passive. It's not casual. It's intense, focused, and growing. Because the implications of what's being discussed aren't small. They point to something more structured, more deliberate, more calculated than what people originally believed. And that's where the discomfort comes in because
the petitioner was not named in Epstein's first or second indictment. 4 other women were named as co-conspirators, but none of the 4 were ever charged. The government could have indicted the 4 named co-conspirators or any of the 25 men that settled secretly with the plaintiff's lawyers, but did not. And then in the context of saying how litigation was used against her in the criminal case, quote, the intervening years were used to exploit the civil litigation process to gain a tactical advantage, using plaintiffs' lawyers in the front and behind the scenes to defame petitioner in pleadings, working the media, promoting fake news, falsely portraying her and Epstein as one person, while working to invalidate, overturn the NPA, the non-prosecution agreement, using the CVRA as litigated in points 3 and 4 above. Again, so the NPA is Epstein's non-prosecution agreement back in 2007 that he signed. She claims she was covered by. She claims the section about granting immunity to co-conspirators means her. But the prosecution has always argued, and this was upheld by the Court on Appeal, that the only people bound by this are Florida prosecutors, not New York prosecutors, so they say her prosecution was legitimate, and the Supreme Court, as I mentioned, declined to hear her appeal. The CVRA, which I mentioned, is the Crime Victims' Rights Act, so it just establishes a Bill of Federal Rights for a victim. But anyway, it goes on to say, quote, Edwards, who is Bradley Edwards, represented a lot of Jeffrey Epstein accusers. Edwards used as the proxy for AUSA Villafana, both conspiring to overturn the NPA through the CVR litigation, obtaining police records and victims' names from law enforcement, and USAO Florida AUSA Villafana sharing information with potential claimants, using the information for secret settlements with men with deep pockets in exchange for keeping the identity of those men out of the public arena to benefit the personal pocketbooks of plaintiffs' lawyers. And she says it's listed out, quote, in 2016, the plaintiff's lawyers met to instigate an investigation into the petitioner. The plaintiff's lawyers representing the complainants had approached the SDNY in 2016 in an effort to promote and instigate a criminal prosecution because the SDFL was not happy with the NPA and the plaintiff's lawyers wanted to assist the CVR case for financial motives. There were 4 employee co-conspirators that were not indicted but named in NPA and referenced in the Jeffrey Epstein indictment. New evidence reveals that there were 25 men with which the plaintiff's lawyers reached secret settlements that could equally be considered as co-conspirators. None of these men have been prosecuted, and none has been revealed to petitioner. She would have called them as witnesses had she known. Okay, Gene, a lot there. But basically the argument is there were these secret settlements. There's other people that could have been indicted. She's the only one that was indicted. She didn't even know about these alleged secret settlements in the civil context, right? Because there was a lot of litigation regarding Jeffrey Epstein and Ghislaine Maxwell. Your thoughts?
There's a famous case called Kyle v. Whitley. It was decided April 19th, 1995, the same day, ironically, as the Oklahoma City bombing. I remember that case very well. And what the Supreme Court said, it talked about the difference between Brady information and what they call Giglio information, Giglio. Brady information is information that raises a reasonable probability, not beyond a reasonable doubt, not even beyond preponderance, a reasonable probability that had that information been provided to the defendant, the outcome of the proceeding, the sentencing, the verdict would have been different. What I hear from you and what I hear from the reporting is of those 25 or so settlements, there's a reasonable probability that had it been...
It means the situation was never as simple as it seemed. It means there were layers that weren't fully explored or fully exposed. And now those layers are starting to come into view, but only partially, just enough to create shock, just enough to trigger questions, just enough to make people realize that they might not have seen the full picture. That's what creates momentum. Not full clarity, but partial revelation, because partial revelation leaves gaps, and gaps invite speculation, and speculation keeps the story alive. That's exactly what's happening. Every new piece of information adds to the conversation, but it doesn't complete it. It raises more questions than it answers. And those questions spread faster than any explanation, because people are trying to connect everything, trying to understand how these details fit into the larger story, trying to figure out what it all means.
Are part of the case file and were reviewed by the AUSAs and case agents during our investigation. None of these videos depict the abuse of any victims or provide evidence suggesting anyone other than Epstein and Maxwell participated in the abuse of victims. SDNY introduced the video recording of the search of Epstein's Palm Beach residence as an exhibit at trial. None of the videos identified above contained potential CSAM, child sexual abuse material. As noted above, there was no videos of any sexual abuse identified at any point in the investigation. There were, however, approximately a dozen photographs containing CSAM found on one of Epstein's devices. Those images were identified by the case agent as CSAM that Epstein obtained over the internet, not CSAM depicting any of Epstein's victims or produced by Epstein. A copy of those images was maintained by the case agent in the case file with the other images and videos seized and identified responsive during the review of Epstein's devices detailed above. Okay, here's another memo. Quote, in September 2019, FBI and SDNY met with victim, redacted. FBI and SDNY were able to verify that Maxwell recruited her and that she was being sexually abused by Epstein and Maxwell and that she recruited other minors. FBI and SDNY were not able to corroborate or verify her reports of being lent out to other men. Her statements regarding being directed to have sex with other men was inconsistent with statements made by other victims and witnesses, in particular her statements regarding being lent out to men with another victim. The other victim denied this occurring. Now, in the spirit of that, there is a July 10th, 2025 email titled, quote, Response to Director's Call. So you wonder if this is FBI Director Kash Patel. And all the names are redacted, but it says, how many victims alleged other men or women abused them? Approximately 4 to 5 victims accused other adult men sexually abused them. There was not enough evidence to federally charge these individuals, so the cases were referred to local law enforcement. Approximately 4 to 5 victims accused other adult women to have taken part in sexual abuse, threesome with the minor, including Epstein's girlfriend, who was approximately 18 to 20 years of age at the time. The girlfriend was interviewed, proffered, but it was determined there was not enough evidence to charge. Now, who that girlfriend could be, I can speculate. I'm not going to say here, but let me go add this. There's a 2019 memo regarding co-conspirators or potential co-conspirators. Like, for example, French model scout Jean-Luc Brunel, who was accused of abusing women out in Europe. He died by his own hand, by the way, while awaiting trial. Here's what the memo says. Jean-Luc Brunel, owner of MC Model Agency, SDNY, is currently in contact with his attorneys and a subpoena has been served. There is limited evidence regarding his involvement. What about Les Wexner? We've talked about him before, the retail guru behind Victoria's Secret, Abercrombie & Fitch. Apparently, Epstein managed his finances at one point. He's always come up as a known associate. Quote, Leslie Wexner resides in Ohio. SDNY is currently in contact with his attorneys and a subpoena has been served. There is limited evidence regarding his involvement. Now, all of this may be very surprising and shocking when you consider the breadth of accusers who have come forward against Epstein and, of course, Epstein's connections to the rich and the powerful, and especially when we consider how many emails there are where Epstein or Maxwell converse with these individuals. And let me tell you, some of them are incredibly disgusting and creepy communications. We've covered it here on Sidebar. There has been fallout. But it doesn't mean that if you knew him or talked with him or hung out with him, that you were necessarily involved in criminal activity or even knew about criminal activity, or that there could be a successful prosecution against you. There might not be enough evidence, but obviously this conclusion by the FBI is very surprising. Now, to be clear, as outlined by the AP, there was evidence that the feds were potentially building cases against alleged co-conspirators. The big issue...
The more they try, the more complicated it becomes because this isn't a simple narrative. It's layered. It's fragmented. It's filled with pieces that don't always line up perfectly. And that makes it harder to process, but also harder to ignore because complexity draws attention. It keeps people engaged. It keeps them thinking, and most importantly, it keeps them coming back. That's why this isn't fading. If anything, it's intensifying because the more attention it gets, the more pressure builds, pressure for answers, pressure for clarity, pressure for some kind of resolution. And when that pressure isn't met with clear responses, it doesn't disappear, it grows. Because silence in a situation like this doesn't feel neutral. It feels intentional. It feels like something is being avoided. And that perception alone is enough to keep everything moving because people start asking why. Why was?
The issue is a lot of those allegations couldn't be verified. And that includes, and I'm not sure if that memo I read before was referring to the late Virginia Roberts Giuffre, it might have been, because despite claiming that Epstein had coordinated her to be engaged in sex acts with other men, including former Prince Andrew, the files show investigators thought there was a credibility issue, even though they believed she was a victim of Epstein himself. They cite a memo that said no other victim was described being expressly directed by either Maxwell or Epstein to engage in sexual activity with other men. According to the AP, when investigators looked at Epstein's bank records, there was no evidence either. For example, yeah, they found payments to all of these models, but there wasn't evidence that he was engaging in prostitution of girls or women to other men. And then we have the client list, right? This idea that circulated that Epstein kept this little black book of everyone he trafficked girls to, right? You look at the AP, they correctly note that this was confusing because Attorney General Pam Bondi told Fox News in February of 2025, when she just got into the position, that the client list was, quote, sitting on my desk right now. But then it was only a few months later in July when the FBI and the DOJ issued a memo stating that after they reviewed all of the Epstein materials, this systematic review revealed no incriminating client list. And that is further amplified in a December 30th, 2024 communication. All the names are redacted, but the memo does address what's known as CACHTU. This is the FBI's Crimes Against Children and Human Trafficking Unit, okay? I'll just call it the unit. So it goes like this. This is the email. Quote, the deputy asked whether our investigation to date indicates the client list, often referred to in the media, does or does not exist. Here's the response. This CACHTU, this unit, spoke to the case agent and confirmed no client list existed. An address book was entered into evidence at trial, but it is not a client list as depicted in the media. The current status of the investigation into Epstein is concluded, and the case is pending inactive. Now, the address book being something that has been in the public for quite some time, this is Epstein's contact list. Again, to be clear, doesn't mean that those people were involved in criminal activity of any kind. But obviously, this is a big conclusion. This is a big development. This is something people have been waiting for. I want to talk about it a little bit more. Can we believe this? Is there something going on behind the scenes? Let's talk about it. Let me bring in former federal prosecutor Rena Paul. Rena, thank you so much for taking the time. Does this conclusion from the FBI based on these communications, does this surprise you that there's no evidence that anybody else had been abusing girls, that Epstein hadn't trafficked any of these victims to anybody else?
Well, I think we should start by talking about this as an investigation, right? And to understand what has come out, to think about it through the lens of an investigation by the government and the disclosures by the government as conclusions rather than the raw evidentiary material. So we're starting there. So when you ask if it's surprising, I mean, I think we have to start with the question of what we are actually seeing.
Okay, and so based on what we're seeing in these releases and based on what we're seeing in these internal communications and emails where they say, we can't find any photos or videos of women or girls being abused by anybody other than Maxwell and Epstein. There are those who say, how is that possible? Unless it was all rumors, unless, of course, Epstein never kept the cameras in those rooms, or he never had any evidence of anybody. He wouldn't record them. Let's just start there.
Yeah, so it seems from what I've reviewed that there's notes of there being
this addressed before. Why are these details only surfacing now? Why does it feel like there's still so much that hasn't been fully explained? Those questions don't go away. They multiply. And every time they're repeated, the story gains more traction. That's how something like this turns into a sustained moment instead of a temporary headline, because it taps into something deeper than surface-level interest. It taps into trust. And once trust becomes part of the conversation, everything changes. Because now it's not just about what happened. It's about how it was handled, how it was presented, how it was understood, and whether that understanding was ever complete. That's the bigger issue, and that's what's keeping this under such a heavy spotlight, because people aren't just reacting to the details themselves. They're reacting to what those details represent. A gap, a missing piece, a sense that something important was left out. And until that gap is filled, the attention isn't going anywhere. It can't, because unresolved stories don't disappear. They linger. They resurface. And every time they come back, they bring more attention with them. That's what this feels like. Not a repeat, but an escalation, a deeper layer being exposed, a more intense reaction building, and a growing sense that this isn't over. Not even close. It's investigative. People aren't just consuming information. They're breaking it down, examining it, questioning it. And that process is what keeps everything alive. Because as long as people are engaged at that level, the story continues. It doesn't fade into the background. It stays in the spotlight. It stays under pressure, and it keeps evolving. That's where we are right now, in the middle of something that hasn't fully revealed itself. Something that's still unfolding, still being analyzed, still being questioned. And until that process reaches some kind of conclusion, if it ever does, this isn't going anywhere. It's going to keep building, keep spreading, keep drawing attention. Because once something like this reaches this level, it becomes more than just a story. It becomes a focal point, a moment that people keep returning to, trying to make sense of, trying to understand, trying to see the full picture. And until they feel like they have it, they're not going to stop. That's the reality of it. This isn't fading. It's intensifying. And as long as that continues, the spotlight isn't going anywhere.